Let's get reaction now on that development. Judges Matter researcher Mbekezeli Benjamin joins us now on that. Mbekezeli, good to have you. Thank you very much for your time. 16 years later, here we are. Others would look at that and say this is an indication of a system that fails to hold judges accountable if it's going to take 2 decades to even get to this point.
Good evening, Taba, and good evening to the viewers. Well, I think some of people would criticize the system for how slow it is. I think they would be justified. 16 years is a very long time for any process to start and finish, but for particularly this one that deals with the integrity of people who hold a huge amount of power in our society, and that is judges. But we must also understand that the criticism must be within a context. At some point when this complaint arose, there wasn't a legal framework for how judges should be held accountable. In 2010, the law had to be amended to create systems to hold judges accountable, and there was quite a lot of litigation that delayed the proceedings. So in as much as the delays were regrettable, but it was trying to build a system. And it also is not fair to blame all of those delays on Judge Hlophe. I think the blame there's plenty of it to go around. But at least now there is a system that functions, and today we saw that system in action.
Why did this matter not end at 2009's subcommittee of the JSE no evidence finding?
So there was the finding by the JSC, but it was taken to court. And in fact, it was the Supreme Court of Appeal that said, no, you can't conclude a case of he said and she said by simply there is no evidence. You have to set up a clear process to test that evidence. And that is why the JSC Act was amended to set up a tribunal. And it was a tribunal that got going in December of 2020, where witnesses came to testify. Judge Hlophe brought his own witnesses, including himself. He testified. The 2 Constitutional Court judges also testified. They were cross-examined. That is the system in which, in our legal system, we test evidence, and that is what the Supreme Court of Appeal said the JSC must do. So it wasn't just simply a rejection of one decision for another. It was the way in which the decision was taken that was problematic, and which the JSC decided to fix by changing the law. So
the information that is out there, including by the judge himself and those who support him, that this was almost a retrial, it was a reinvestigation, a matter that was previously investigated, and a finding was issued on it, and the High Court said his rights were limited and violated. That particular matter was reversed and retried again.
Well, that is why there was an appeal to the Supreme Court of Appeal, because there were disputes over whether can really the process end at simply saying this one is saying this one is saying that, and we end there. That is why the Supreme Court of Appeal said, no, the Judicial Service Commission must attest this evidence, because the 9 Constitutional Court justices who had laid the complaint were saying one story. Judge Hlophe on the other side was saying a different story. So which story is believable? And which is why the Supreme Court of Appeal said, no, we must set up a tribunal to test this evidence. And that is how the tribunal came to be. And in fact, even when the tribunal was running, Judge Hlophe was the one who admitted some of the evidence from the previous proceedings, and they only dealt with the new evidence that related to his own testimony and the testimony of Justice Nkabinde and Justice Jafta.
So others, I suppose, quite key for yourselves as well, and others who are watching this case, is the fact that this would then, I guess, set a precedence, maybe even a case law of what it means when the judiciary is talking about cases with each other, where others are saying, well, this is general practice within the judiciary.
Well, one of the most important things that we when one of the most important lessons from this episode is how much actually it was the judiciary that stood up both for the cases of Judge Mutata and Judge Hlophe. It was the judiciary, the judges themselves, who said this thing needs to be properly investigated through a proper procedure. So it wasn't a case of judges trying to protect each other. And that is, I think, the lesson that goes into other tribunals. Tomorrow morning, there's another tribunal that will be running in relation to another judge. And so the lessons that we've learned over the last 16 years do carry forward. But of course, Judges Matter, as people who have been following this process quite closely, we still have a lot of criticisms. The slowness of the process, the complexity of the process are things that we think are a risk to the independence and reputation of the judiciary.
So the other issue that was raised is there are legal processes that the judge would have been involved in. There are legal cases that are currently going on that he would be overseeing. And hence he was saying, well, what's the rush? There's no rush. This will create a whole problem in the system in terms of the cases that I'm working on and all the legal processes that are going on there. What's going to happen now?
Well, there are currently no cases that Judge Hlophe is dealing with, as far as I'm aware, because he was suspended in December of 2022. And the condition of his suspension was that he finalized any cases that he had at that time. It's been a little over a year later, and I'm sure all of those cases have been dealt with. The rush that he was speaking about actually was to say he still has a case pending at the Constitutional Court, and so Parliament should not go ahead with today's vote until the Constitutional Court case is resolved. And that was also part of the argument that he brought in the Western Cape High Court application, the urgent application that he filed. He was saying Parliament should just wait until the Constitutional Court case is resolved. But of course, we got an order or an answer from the Western Cape High Court through Judge Potteril, who said that no, you still have redress available through the Constitutional Court process, so the case can still go ahead. Parliament doesn't need to wait until that case is resolved.
So I suppose that would mean even the president at this particular point can't really act on this. He will be notified by Parliament, but he would have to await that Constitutional Court process.
No, the president doesn't need to stop. He can go ahead with implementing the National Assembly's resolution, because even Section 177 of the Constitution says that the president must implement the resolution of the National Assembly, and the president doesn't have a choice to say, I am not going to implement it because of I'm waiting for another process. Because again, what Judge Hlophe is asking for in the Constitutional Court case is that the Constitutional Court must check whether Parliament is actually following the text of the Constitution. Should Parliament set up a separate inquiry? Should Parliament have different rules of how to impeach a judge? Those are the questions that are before the Constitutional Court. And if the Constitutional Court says, yes, we agree with Judge Hlophe, then they will set aside this vote. And once the vote is set aside, then the president's decision will also fall away as a result. So there's no stopping the president. He can still go ahead.
But is that likely not going to hit a snag? Because there are some in Parliament who believe that Parliament should have engaged with this particular report than merely just accepting it. So suppose there are those who are looking for a similar, and I know we've spoken about this before, a similar process as that of the public protector, where there will be people who come in, evidence will be led, and so on and so forth. They say, but this did not happen. We just engaged with the report of the JSC.
Well, that's the beauty of Parliament and the debating process, right? We can all debate and have our views. Well, at least the members of Parliament can debate and have their views. But the High Court had already said what the process should be, that once the JSC takes a decision on a judge's misconduct, Parliament can't reopen the inquiry to check whether the judge actually committed misconduct. Parliament has to debate. Parliament has to persuade each other whether, now that the JC has made a finding, should the judge be removed from office. And those are the limitations of the debate, whether or not the judge should be removed from office. And the parliamentarians must find each other on that issue. Today, the Parliament voted that the judge should be removed. We don't know whether tomorrow it might come with a different outcome in a different case involving a different judge. So that is the work of Parliament, which is very different from the work that the Judicial Service Commission is tasked by the Constitution to do.
Yeah. So you have, for example, members of this committee like the IFP who want to applaud the judge for his excellent mind in the space and the contribution that he has made. And then you've also got the argument around the transformation of the judiciary as a person that many are saying had pushed back on those who were refusing transformation. Where does that leave that debate?
Well, I think the debate is still ongoing. I think Judge Hlophe will still continue to be a part of the legal community in South Africa, and we can assess his legacy. In fact, he has made a significant contribution in the transformation of the Western Cape High Court in terms of its demographics. He's brought on a diversity of judges of that court, and he did set up some of the systems that help the Western Cape High Court to be a functioning court. But the accountability that we saw today is in relation to his conduct, which the Judicial Service Commission did say it was gross misconduct. It fell below the standards that are expected of judges. So there are two separate debates, and of course when you're debating someone's legacy, you can be persuaded left or right, and all of us can have views.
Mbekezeli Benjamin, appreciate your time. Researcher at Judges Matter there with us following the development at the National Assembly. Right.